surprised. Okay, Platt versus Windsor owners, submitted. Our first case on the calendar, Bronson versus Jacobs. Okay, you can proceed, Counselor.
Good afternoon, Your Honors. May it please the Court, Lisa DeBella, Marie and DeBella, on behalf of Appellant Stephen Jacobs. As this Court's decisions recognize, the issuance of summary judgment on a CPLR 3213 motion without the benefit of any discovery is a drastic remedy. And a trial court's role in such a motion is limited to determining whether issues of fact exist, not deciding them, and not assessing credibility. We're here today because the trial court ignored this standard and explicitly said so much on the record. During oral argument, the trial court stated, and I quote, "A lot of times I will say in court, in general, maybe I shouldn't go too far here. A lot of judges can say there's always a factual issue, but our job is to decide stuff."
So we have a promissory note for $258,800. It was not paid. What is the issue?
The issue, Your Honor, is that the promissory note was made to repay a string of illegal gambling loans, so it's illegal because it's void in New York, that it was signed under duress, and that duress continued almost until the date this case was brought, and that the note...
Where is there in the record that states that the loans were made for the benefit of any type of gambling?
So, Your Honor, if you would look at my client's affidavit, the record at 77, he states in paragraph 12, Bronson also knew, that's
based on what? Is there anything on the note itself that says this is for the payment? Or
the note itself says that it's to repay a string of loans that were made from August 2012 to December 2016. There's nothing on the face of the note that indicates that it was an illegal gambling loan, but that's not surprising, right? Why you wouldn't have anything on the face of the loan that indicates that it's usurious, and it's not surprising.
Wouldn't you, in order to defeat summary judgment in lieu of complaint, wouldn't you have to show more than just the debtor coming up and saying, oh, it's for gambling debts, and he knew? Don't you need more than that to create?
Your Honor, I think we have more than that. We have the debtor coming up, and he offered a specific and detailed affidavit, which the case law holds is enough, but it's corroborated both by the press affidavit, in which his friend, a friend of also of the respondent, says, "I witnessed some of these gambling loans.
Counsel, how do you explain then he made 41 payments? Did he make 41 payments?
He did make 41 payments, Your Honor. He made those payments under a continuing campaign of duress. Even after the note was signed, the record evidence shows that the respondent in this case continued to threaten my client's mother, repeatedly threatening to go to the legal authorities and to my client's employer if he ever stopped making payments on the note.
So what's wrong with that? I mean, why is that legal duress that would otherwise make the note unenforceable? In other words, was he? I'm just not understanding duress in the legal sense. Because he says, "I'm going to go to your employer and say you're a gambler," right? What is he going to say?
Not only does he say, "I'm going to go to your employer and say that you are a gambler and entered," he basically he said he was going to accuse my client of fraud, and this is in the record. And he didn't just say he was going to go to my client's employer. He said, "I'm going to go to New York legal authorities." So my client thought that he was going to the police and that he was going to essentially ruin my client's life and career. And that's the definition of duress. I mean, the case law in New York is pretty clear that threats to go to the police are enough to establish a legal claim for duress.
New York legal authorities would be the police, as opposed to in line with the fact that your client was an attorney, and so perhaps the New York legal authorities would be the disciplinary committee. But again, how does that constitute duress? And I'm going to tell your mother? That is duress?
Well, no, I mean, his mother
Wait till I tell your mother.
The duress wasn't that I'm
duress?
going to tell your mother. The duress was that he went to his mother and threatened that if her son stopped paying, he was going to expose him to the police and to go to his employer.
I thought it was that he called the mother, repeatedly called the mother and said, "Your son owes me money and I want my money."
After the note was signed, he repeatedly called his mother and said, "Your son owes me money, and if he ever stops paying, I'm going to go to the police, and I'm going to go to his employer, and I'm going to essentially ruin his life and his career." And the case law says that a threat to go to the police is enough to establish duress.
And which case law is that?
One moment, Your Honor.
They've known each other since 6th grade, correct?
Yes, Your Honor.
Yep, so much for friendship.
So much for friendship. So the improper threat,
You'll be able to tell us on rebuttal, but
Yes.
here's my
I will,
other
Your Honor.
question to you, is that when he signed the note, it was a negotiated note, and your client had the benefit of counsel, didn't he?
no, my client did not have the benefit of counsel when he signed the note. He represented himself.
But he's an
He wasn't-
attorney.
He was, right.
He's an attorney.
He was an attorney, but in fairness, he was, a very, very young and inexperienced attorney, and
At a
admittedly,
major law firm here in New York.
he was a he was a junior
Third-year
associate.
associate at a major law firm here in New York, but you're claiming that he's still a novice at law?
He was, I think he was, Your Honor. I think he was
Really?
a
What
novice of
practice
law.
was he in then, at this major law firm?
He was doing an investigations and white-collar
So he
practice.
was in litigation.
No, from what I understand, and this is not in the record, he was an investigative attorney. He wasn't doing litigation.
Okay, thank you. You'll have time on rebuttal. You can proceed.
May it please the court, Mark Kaufman from Kaufman and Kahn on behalf of the respondent, Jonathan Bronson. The court has correctly found that the respondent was an attorney, an experienced attorney. He did negotiate many other parts of the note as set forth in his exhibit to his own
Your
affidavit.
adversary alleges that your client was aware of the fact that these monies were going to go towards gambling debts and gambling.
That's what they allege, but the entire basis for that allegation are the self-serving and conclusory allegations of the appellant himself. As for his mother's affidavit, it is entirely secondhand.
Well, wasn't there a friend who had witnessed communications regarding the purpose of the money that was lent by your client?
Well, they use the word witnessed, Your Honor, but in fact, there's no indication as to when that conversation took place, where it took place, that had anything to do with, here is some cash or here is a check to be used for gambling. There's no allegation other than using the word witnessed and recalling a restaurant conversation.
Well, let me ask you a question, because you made it in terms of giving money for using to bet in the future. Does the statute otherwise cover money for an antecedent gambling debt?
Well, it only says knowingly provided for the purpose of gambling. And
So it could be an antecedent debt
it could
as
be, but he
well.
still has to prove what knowingly is. He still has to prove the indicia of what my client knew at the time.
Well, there was also, I thought that there was an allegation that that he had supported himself through law school by online poker.
Well,
And by other gambling activities, and this is
there's
how
certainly-
he supported himself, this is how he got through college or something, and that your client was aware of this?
Well, he certainly was aware that, and the appellant's own words are that he compulsively gambled. And he says that he would spend 5 hours a day while attending the University of Pennsylvania gambling in their apartment. But that the knowledge that he's a compulsive gambler does not mean that the money was provided for the purpose of gambling. If that were the case, then anything engages in illegal activity, of which activity is known by the lender, all of it would be void. Regardless of the lack of documentation or valid supporting affidavits.
What about the threats, the argument as to duress, that
Well-
your client threatened to tell the police, his mother, as well as the law firm?
Well, first, as a matter of law, the 41 monthly payments are well above the amount necessary to ratify a loan. And there's case law providing that as few as 2 or 3 months is sufficient, and 30 months is sufficient to show that they accepted this and it's too late to repudiate on the basis of duress. As for any continuation of it, it makes no sense that the allegations of fraud would be important because the allegations themselves, as described by the appellant, are ridiculous. The allegations are that the respondent believed he was lending money for the purpose of giving it to a superhero. That's the way the appellant describes it. Why would anyone at a law firm or at the police believe such a thing? And I might add that he doesn't say in his affidavit that the appellant was threatened with the police. He was threatened with unspecified legal authorities. And this is very different from the other cases in which the continuing duress was
Well, your adversary just stated that your client told the mother that he was going to call the police if, in fact, her son did not pay.
No, it's the same thing. They don't even allege the word police coming from his mother. They say supposedly repeated New York legal authorities, doesn't specify what they are.
I guess then the argument is if it was truly harassment that your client was perpetrating, they could have gone to the authorities going the other way.
Absolutely.
Your client for harassment.
Yes, they certainly could have, and that was suggested by the court.
Because there's debt collection rules that we have in place, right? I mean, if your client could be considered a debt collector, I mean, he's got to play by the rules too. So your client will be subject to a lot of penalties for doing what he's doing.
Certainly, and if it had at least gone to the police and made a report, at least then they would have some sufficient evidence to show some paper trail over a 3.5-year period of objecting. The only time they objected was in June of 2020 after receiving 3 default notices. Certainly, providing notice of default can't be deemed to be harassment, particularly when it was provided in the note itself. As for usury, I want to address also the defense of usury makes no sense where the the appellant has failed to allege even the amount that was borrowed.
Well, actually, the loan doesn't even have an interest payment. If he had paid on time, there was no interest, right? Correct?
That's correct.
It was an interest-free loan.
It was an interest-free loan. That's correct. It says it's
Isn't
for
that
principal
odd?
only.
Doesn't that raise questions in and of itself, since it was a consolidation of debts that had occurred before over the course of years?
I don't know
There's
why
no interest component built into that.
the party.
Unusual.
Say again,
An
please.
unusual negotiation.
They're friends since childhood.
Well, not such good friends,
Well,
apparently.
Not at this point, certainly not.
Well,
But it was a matter
whatever.
of consolidating in one place rather than having to chase the appellant for payments now and then when he might get around to it. Here is a payment plan. Here we are. Here's the total amount that you owe me. Please pay it in amounts that you establish you can afford.
Okay, thank you. Let's hear from your adversary on rebuttal.
Thank you, Your Honor.
Go ahead.
I'd like to pick up on the point that you just left off. No, Your Honor, it doesn't make sense that the note didn't have interest, and that's because the real character of the loan was that it included interest. And the documents that we submitted, that were submitted as attached to exhibits to my client's affidavit, prove that.
Right, but why? I mean, here's the thing. You have a client. He's a pretty smart guy, right? He went to great schools. He's working for a prestigious law firm. He didn't keep track of this. He didn't keep his own little ledger about what he was lent and what he owed and what the interest was. I mean, isn't that a little odd, too?
So it's not a little odd, Your Honor, and actually it's in the record, and I'm glad you brought it up because the record evidence showed that the parties did keep track of every one of these loans and that there's precise evidence of the exact amount of each loan.
No, actually, it didn't. It didn't. Your claim is that the respondent kept track of it, but you have a smart guy, a smart client. He's not going to keep his own records. He doesn't know what the interest rate is.
Your Honor,
he doesn't know what he owed before he signed the note. He doesn't know what component of it was interest. He doesn't know what the interest rate was going forward. I mean, it's really kind of at least a head scratcher.
It's not a head scratcher, Your Honor, if you remember that they were friends since 6th grade. That these loans, that they
this
were
friend
roommates.
thing- So we can't rely on the friend thing for the idea that he got a note that didn't provide for interest because they weren't that good friends, but we should rely on it that they were friends for the fact that your client didn't keep track of his own business affairs?
You shouldn't rely
Does
on
that make any
the-
sense?
Well, it does if you look at it in light of the evidence and the documents which
Yeah.
show the respondent's counsel actually admitting and not disputing that the note included interest.
Okay,
I think
thank you.
it raised a doubt.
Thank you. Thank you both. Walker Vines versus New York City Health. Okay, Appellant, you could set up.
May it please the court, Deborah Reeser on behalf of plaintiff appellant Kevin Vines as administrator of the estate of Carleen Walker Vines. Good afternoon, your honors.
Afternoon.
The lower court, first of all, I don't want to be a broken record to the last appeal. However, the lower court viewed the evidence in the light least favorable to my client. My client had deposition testimony indicating her visits and her best recollection of her treatment with Drs. Chan and Narula. But what's most important is the lower court, and it's page 814 of the record, I'm sorry, 821. They were dead wrong. They said no treatment was provided for chest pain complaints after 6/07. This is completely incorrect. As a matter of fact, of course, I guess that acknowledges that on 3/10/05 there was the first complaint for intermittent chest pain. In response to that, Dr. Chan did an EKG and told the client and the patient to go to the hospital if the chest pain worsened. In 11/30/05, although my adversary does not note it, Dr. Chan says atypical chest pain monitor. And in her deposition, she said she wanted to carry it forward. That's 598 and 599. She says in 11/30/05, she gets chest pain and tightness.
So did Dr. Chan render any treatment to your client after 2009?
After 2009, it's all continuous because in 2009, the last visit of Dr. Chan, or so they claim, my client testified that she saw Dr. Chan as a walk-in and Dr. Chan ordered x-rays for her. And there's an indication in the record that x-rays were ordered. And,
so my question was, did Dr. Chan render any treatment to your client after 2009?
Well, Dr. Chan, I was going to finish. She indicated that the next visit would be 6 months hence. She indicated that their prescriptions would be continuing for 6 months hence. And then Walker Vines came in to see her, and she was not in, and that's why, the only reason why Dr. Narula saw her in September of 2010.
So let me ask it another way. Did Dr. Chan render any treatment to your client after 2009?
She ordered chest x-rays.
So the answer is really no, right? After December 17, I think 2009, Dr. Chan rendered no treatment to your client. And that was the basis, I thought, of the Supreme Court, the motion court's decision as to Dr. Chan.
Yes, but as to the Bronx Care, who employed both Dr. Chan and Dr. Narula, and Bronx Lebanon Hospital, who employed the ENTs, that was not indicated because it's a continuous course of treatment from 2007, actually 2005.
But even then, with Bronx Care, when your client went to Bronx Care for the and there was a chest imaging or a chest X-rays, right? They were all clear, right? And also, any cough that she had complained of was no longer prevalent. She no longer had the cough. It was controlled by medication, I believe, and the x-rays, the chest x-rays were clear, right?
No, that's not correct. The record indicates that there were episodes of violent coughing. This is from approximately January 2009 to July or August 2009. Now, Dr. Chan saw my client after another complaint of chest pain at the hospital in August of 2009, where an x-ray was taken. There were abnormalities which were not picked up. So there was an abnormal chest x-ray in 2009, which accorded with her symptoms, according to both of my experts. So that
I have in here that
is that reference to an abnormal chest x-ray in August 2009?
No, they did not find it, but it was reviewed subsequent. The Bronx Lebanon did not find an abnormality in the chest.
No, all the readings of the chest x-rays up until 2011 came back clear.
Right.
Or at least they were read as clear, correct?
They were read as clear
Right,
incorrectly.
and where in the record do you have that was a mistake? Where? I didn't see it, quite
My
frankly.
radiologist affidavit indicated
that was my question, because I thought that the chest x-ray was normal. I'm looking at record A1816. It says chest x-ray normal.
Well, that is what Bronx Lebanon said, but my expert reviewed that x-ray and found an abnormality at the area of the mediastinum.
Well, what was the abnormality? I mean, ultimately, she was diagnosed because masses were found in the chest x-ray.
Correct. It was
And that was in 2011.
This was a contour abnormality that showed up that was not in the March 2009 x-ray. And those two were compared, and it showed up as an abnormal contour in the area where she was complaining of the pain.
Okay, thank
so
thank
this-
you. You'll have some time on rebuttal.
Okay.
Thank you.
May it please the court, your honors, Nicholas Tam from Schaub, Omni, Citron, and Spratt on behalf of the Bronx respondents. I'll keep it brief. I think this case hinges around what the plaintiff's experts said and didn't say. At the very outset, neither of plaintiff's experts made any definitive statement within a reasonable degree of medical certainty that any of the complaints from 2005 or 2007 relating to chest pain were ultimately traceable to the thymoma that was ultimately diagnosed.
So, and that's key, because this is a failure to diagnose case, correct?
Yes, Your Honor.
So in order to have a continuous treatment, the symptomatology, there has to be symptomatology indicative of the disease that is otherwise being treated during that so-called tolling period, correct?
Yes, and I would agree with that 100%. And in this case, there's actually a misquote by the plaintiff that tries to lump Dr. Chan with Dr. Narula. Dr. Narula's note from September 26, 2000. Sorry, let me get the year right.
Well, let me get you to another point which
Yeah, sure.
your adversary was bringing up. She said her radiologist, in looking at the 2009 chest x-ray, said that there were abnormalities that weren't caught. Is this true? And what were the nature of the abnormalities? And or were they symptomatic of a
Thymoma?
yeah.
No, and I think it's...
Well, that's a tripart question, so no to what?
Yes, I think it's telling that the...
No, just answer the question. Don't tell me. Just answer it.
Okay. I think it's telling that the plaintiff was unable to cite anywhere in the record that indicates an abnormality in the chest x-ray. And I think
So your answer is no, the radiologist didn't find that the 2009 chest x-ray showed an abnormality?
No, no.
Okay.
And-
And so per force, it didn't show anything that would otherwise deal with symptomatology that was connected to the thigh, and I'm sorry, I'm mispronouncing.
Thymoma, right.
Right.
That's correct. And the key here is the rib pain that was drawn out and reported later on at Danbury Hospital in 2011. Dr. Narula's letter makes no mention of any rib pain. That is a distinct and separate symptom. That deals with a anatomically distinct location that was corroborated by not only the medical records from Danbury in 2011, but also the PET scan. There were none of these symptoms, and actually the plaintiff had testified to this distinction on Appendix 245.
Well, Dr.
What?
Narula's letter does mention that she had, in the last 2.5 years, left-sided chest pain and a persistent cough.
And that's not indicative of, let me rephrase that, the records speak for themselves. That letter was drafted for the purposes of Medicaid, and the records speak for themselves here. There is no continuous treatment over a course of 2.5 years if you look at the records.
So it's your position that the rib pain was different than the chest pain?
It's absolutely different.
When
and the
did she,
Yes.
the answer to that is yes.
Yes.
Okay. So when did she first complain of rib pain as opposed to chest pain?
So the first distinct complaint to Dr. Narula, who is separate and distinct from Bronx Care Clinic and Dr. Chan, which the plaintiff attempts to merge everyone into.
We understand that argument. I'm
Yes.
just trying to get an answer.
Right, so the first distinct one was October 21st of 2010. It was pain under the left breast, not the chest, and that is replicated thereafter at Lincoln Hospital emergency room, pain to the lower rib cage, constant and increasing. The follow-up in March 2011, intermittent left rib pain reproducible. And then finally at Danbury Hospital, when all the masses are found, chest imaging confirmed multiple masses concerning for thymoma. None of these symptoms were treated by Dr. Chan during the relevant time period. And for these reasons, there is no continuous treatment. This is a failure to diagnose. Thank you.
Thank you. Okay, we'll hear on rebuttal.
Just to follow up on the radiology expert. So the expert opined that the chest frontal film of August 6, 2009 contained a discernible abnormal change from the earlier x-rays. It exhibited a new contour abnormality. There was a loss of the left heart border silhouette on the film, and the radiologist said with a reasonable degree of certainty that Walker-Vine's thymoma was clearly consistent with the x-ray demonstrating the abnormal finding in the anterior mediastinum.
All right, and can you just give me the record
Yes,
page number to that, please?
2295 to 96 and 2300 to 2301.
And what's the name of the radiologist?
The name of the radiologist is Dr. Mayer, but we did not, originally include that. The court had asked for that. Did not ask for the name. But. In a separate affidavit, though, I just want to point out that the oncologist noted that the radiological evidence was consistent with clinical complaints of both chest and rib pains, and said...
What was the oncologist looking at when he said radiological evidence? I don't know what he's
No, the
specifically referring to.
radiological evidence found by the radiologist. He said the radiologist's findings were consistent. I just want to say that
So he's talking about your radiologist?
Yes, all
Are
opinions...
you saying yes, like I should know that?
Oh, I'm sorry.
All right.
All opinions were to a reasonable degree of certainty, and the court did find that the plaintiff raised questions of fact because the oncologist rejected Dr. Rothman's conclusion and their own expert, who said that, yes, chest pain is consistent with thymoma. Chest pain would be seen with thymoma. Dr. Narula testified to that. Dr. Chan testified that.
So your position is that there is no difference between rib cage pain and chest pain?
It's basically, as the court ruled in Devadis versus Nick Sarley, it's a condition. She had coughing, consistent coughing, which the client said the doctor said has to do with her GERD or her chest pain. They gave her different reasons. Or the chest pain was constantly monitored in 2008, because after the echocardiogram, the Dr. Chan said, "Oh, I can't figure this out. She's got to go get weight loss." Sent her to a nutritionist.
All right.
Sent her, kept going on and on and on. And
All
then
right.
when the cough.
We understand your argument. Thank you.
Thank you.
All right, step up on People versus Thurinay. I'm sorry if I mispronounced that. You may proceed.
Court. Good afternoon, Your Honors. Jamie Hinan Wong, a law intern from the Office of the Appellate Defender, on behalf of Mr. Sergei Theronier. The crux of this case is one word: public. Disorderly conduct's public harm element is about the intention or reckless creation of provoking public disorder. Just as it was in People v. Baker, the dispute here between Mr. Theronier and two trained police officers, where Mr. Theronier simply sat quietly on a window ledge, then reacted emotionally to perceived harassment, did not reach a public dimension.
The main concourse area of the Port Authority bus terminal?
That's correct, Your Honor.
It's not public?
It is a public area. However, if we look to the contextual analysis employed in Baker, the location and time is actually very similar to the one as it was in Baker. It was during daylight hours in a heavily populated area. Here, as you noted, Mr. Theronier was in one of the busiest locations in New York City, Port Authority bus terminal. Looking at the analysis as if there's a public risk, such as disrupting the peace and order of the vicinity, there was really no risk that he would disrupt other passengers in one of the busiest locations, and there's no evidence in the record that he did disrupt other passengers. As the Court of Appeals emphasized in Baker, the public harm element was created to distinguish individual disputes like these from situations where there's an actual risk of public harm. A dispute with another person where expletives are used in a public place does not, in and of itself, constitute disorderly conduct.
But Baker also said, if I'm not mistaken, it talked about the fact that you didn't need a certain number of members of the public to be involved, nor did you need a certain number of members of the public to actually react
That's correct, Your Honor.
to the incident. So again, we're in the main concourse, Port Authority bus terminal. We're pre-COVID. So I'm assuming there are a lot of folks in the bus terminal going to wherever they're going. So again, I'm not understanding why even under Baker, and more so under Weaver, why this would not be a risk of some type of public disruption.
That's correct, Your Honor. However, to address the point about members of the public being involved, no members of the public here actually became involved in the dispute or showed any inclination to do so.
Well, we're also talking about New York, right?
That's correct, Your Honor.
So putting it in the context of New Yorkers, again, we're in the Port Authority bus terminal. They see two police officers who are engaged in an altercation or discussion with the defendant, who is apparently raising his voice. I mean, there's apparently some shouting of profanities, et cetera. So again, I don't see how even under Baker and under Weaver, again, we don't have a public inconvenience and we don't have a public disruption.
As a New Yorker familiar with ignoring other situations in bus terminals, it's important to note that the analysis is about the risk of public disorder. And Baker found that a gathering of spectators, even if they are there out of mere curiosity, is insufficient. It's required disorderly conduct.
I just said, maybe I'm confused, but ultimately your client got convicted of assault and resisting arrest, so that it may have stemmed from public disorder, but he got convicted for second-degree assault and resisting arrest, correct?
That's correct, and I can explain why probable cause.
He went after the gun, he went after the weapon, the officer's weapon, during the struggle, correct?
That's correct. However, here we're engaging in a probable cause analysis. So in the conviction, assault on the second degree and resisting arrest, they require a lawful duty and also an authorized arrest. Under that, the arrest required probable cause. And since we're engaging in a probable cause analysis, we're limited to the information that the officers knew at the time of the arrest. Facts such as Mr. Theronier reaching for the gun are not factored into that, since that was after the arrest began.
But also, because it is probable cause, we don't need to have that degree of evidence that would have otherwise sustained a conviction for disorderly conduct. We just have to know that the police had probable cause to otherwise engage him and possibly arrest him for that, right?
That's correct, Your Honor. And
So it's a different standard when we
Yes.
look at the nature of the conduct, correct?
correct. Since it is a probable cause analysis, the standard is different. However, even under a probable cause analysis, the officers lacked the basis to arrest him. Disorderly
So
conduct.
they approach your client, they ask your client, they tell your client he can't sit where he wants to sit on this windowsill ledge or what have you. He then asks why not, where are the rules, why aren't the rules posted here, where the windowsill where I'm sitting. He then apparently begins to, again, shout obscenities. He's flailing his arms. He's hitting the window. He's engaging in this activity, slamming the window with his hands, etc. Why does that not constitute disorderly conduct?
Well, we are not disputing that the police officers had a right to approach him or even to question him or tell him not to sit there. They did not have the probable cause.
Why would they not have the authority to approach someone to say?
We are not disputing that. Sorry, Your Honor, I may have
I'm sorry.
misspoken. We are disputing that they did not have the required probable cause to arrest him because disorderly conduct's public harm element, as the Court of Appeals detailed explicitly in Baker.
I don't think, you know, you're right about the probable cause to arrest him. I think they went over there, and my understanding of the record is that the officer said, please get off the ledge, you're not supposed to be sitting on that. And then it just kind of escalated from there so that the sort of a warning or please move on, or you got to move on, that, I don't think they were going into thinking they were going to arrest him. The record, it seems to be otherwise.
If I can answer, even though time has expired.
You may answer that question.
Thank you, Your Honor. Here, it's more about what they knew at the time of the arrest. They lacked the probable cause requisite to arrest him, and because of that, the public harm element that was explicitly ruled in Baker was really created to distinguish individual disputes like these from situations where there is an actual risk of public harm.
Thank you.
Thank you.
All right, we'll hear from the people.
Good afternoon, and may it please the court. Excuse me, Molly Morgan on behalf of respondent. The Port Authority officers reasonably perceived a potential for public harm. Defendant escalated the interaction with Officer Stephen and slammed his fist on the glass and proclaimed that Officer Stephen would have to effing arrest him. And as Officer Stephen testified, he was, quote, causing a crowd to gather and, quote, causing a disturbance.
Can you tell me, what is the evidence that there was a crowd gathering? And try to phrase it in terms of some of the surveillance camera footage.
Yes, Your Honor, absolutely. The surveillance video does not explicitly show a crowd gathering, but as one of the officers testified, the vestibule was surrounded by glass, and so the officer's testimony that a crowd was forming isn't inconsistent with the surveillance video because it's certainly possible, it's reasonable to infer that a crowd was gathered just beyond the frame to the left, as that was glass. perhaps even on the street, although the video quality is not the
Not
best.
great. It's
Yeah.
not great. Yeah.
Yeah, so in that respect, the officer's testimony that there was a crowd wasn't inconsistent with the video. I'd also note that unlike Baker,
Did they both testified about a crowd, both police officers? I just don't know. I don't remember.
I believe it was just Officer Steven. She testified that at pages 395, 398, and 408.
You were just going to go on to Baker. Weaver, I believe, took place in a parking lot, right? Where was Baker?
Baker took place on a residential street that was somewhat bustling with pedestrian activity. Certainly not as bustling as the Port Authority bus terminal. That also brings up the point that, Weaver squarely refutes defendant's suggestion that the public has to be involved in any respect. In Weaver, there were some people nearby, there was a mini mart open, and none of those people expressed any inclination to get involved, and still, the conviction for disorderly conduct, there was sufficient evidence.
But that was
Because,
a public disruption, right? Weaver talks about a public disruption.
right, exactly. And as Weaver made eminently clear, all that's required is a potential for public harm. No one has to become involved. I'd also note that, the surveillance video does depict several people passing through the terminal and kind of pausing and turning their heads.
Right, they kind of look, and then they, as New Yorkers do, kind of walk in the other direction.
Yeah, absolutely.
Yeah.
Yeah, they carry on their way, and I would suggest that it's reasonable to infer that, they certainly still could have been alarmed or annoyed or inconvenienced by this, but they decided not to actually literally engage in the dispute for any number of reasons, but just because they didn't do so doesn't mean they weren't alarmed. And again, all that's required is the potential for public harm. I'd also note that Baker is also distinct in several important ways. In Baker, the officer was safely in his patrol car, and the defendant made 2 abusive statements as he was backing away. Here, we have a totally different context. The officers are face-to-face with defendant, just trying to get him to stand up from the spiked windowsill ledge where he was seated. And also in Gonzalez is distinct in important ways as well, because in Gonzalez, the defendant walked past the officers and up a flight of stairs as he was ranting about the officers having blocked the staircase. And here again, the officers really, they were not in a position to ignore defendant as he shouted. His conduct escalated. It culminated in him telling the officers that they were going to have to effing arrest him, and they clearly were not in a position to ignore that. I'd also note that, going back to Weaver, it's instructive because there the defendant's conduct was escalating, and the officer determined that the defendant in Weaver was not going to stop creating a disturbance. Similarly here, in the context of what the defendant was saying, there was really no chance that he was going to peaceably comply. I mean, he was agitated from the start, and his conduct only escalated. It culminated in that proclamation, and really, I would suggest that any passerby could see that a physical encounter was going to erupt. And Officer Stevens' conclusion that this was going to continue to escalate is further supported by the fact that it did escalate, and one of the officers' heads was slammed into the floor, and the other officer suffered a quite serious back injury that's caused her problems to this day. So that goes to further support that initial apprehension that things were not going to calm down. Unless the panel has further questions, we ask this court to affirm. Thank you.
Any questions? Oh, I guess no questions, colleagues. Thank you. Okay, rebuttal.
Your Honor, to first address respondent's point about escalations, the court in Baker actually is explicit about how police officers particularly are trained to handle emotionally fraught situations like these. And there's no evidence in the record that here, where the dispute was between Mr. Thronier and only 2 others, 2 police officers, they did not make any effort to de-escalate, and no members of the public became involved. To address Weaver, also, the analysis when it
I'm
comes...
not so sure the video recording backs that statement up in terms of whether or not there was a de-escalation. I think, when I looked at the video, it didn't seem that way, but go ahead.
To continue on, Your Honor.
There is a video, you know, okay.
To address Weaver, the context for the analysis of the public harm element is about the creation of a public risk of disturbing public order. For Weaver, the risk was high because it was quiet.
So let me ask you this question. We get into these factual scenarios about what is a public disturbance and what is not, and, you know, it takes a lot of finesse and it's a lot of gray area. This was all before a jury, correct?
Correct, Your Honor.
The jury got to watch the video, right? So that's a determination that the trier of fact is going to make, and whether or not the gray area is crystal clear to them. Right, so these are determinations that I mean, you're making this pitch to us, but this is something that trier of fact has to decide, right? And look
That's
at
correct.
it and view the evidence.
We're making two claims. We are making a legal sufficiency claim and the weight of the evidence claim. Sorry. The legal sufficiency claim does not require disrupting the jury's determinations because the court can find that here in this situation, which was much like Baker and in some ways even less offensive, the evidence was not sufficient to find the public harm element. Here, it was less offensive than Baker because, for example, on the profanity used, the defendant in Baker directed them at the officers. Here, Mr. Droney was merely expressing his frustration at perceived harassment. He did not insult them. He did not try to touch them. And
You don't really think that you're in the Port Authority, you hear somebody screaming obscenities while police are standing there, that as a bystander, you wouldn't find that at least concerning? You would just think it's frustration?
Well, it
In
might...
New York? Even for New Yorkers?
It may be concerning to a bystander, but what disorderly conduct requires is that they have probable cause for really a higher bar.
We understand that. We understand that. Okay, thank you.
Thank you, Your
Hey,
Honor.
thank you both. Thank you both for your arguments. And the next case is King versus Board of Education. You can proceed, Counselor.
Thank you. May it please the court. I'm Daniel Matza Brown, here today on behalf of the City of New York, the Board of Education, and the Chancellor of the Department of Education. DOE's in-school COVID testing program.
So, Counsel, I'm sorry. I am totally perplexed by this, and I really need you to explain it. How would this possibly violate the Establishment Clause?
Your Honor, our argument is not that this violates the Establishment Clause.
Oh, because I thought that's what the...
And that is, if that was the impression my briefs gave,
Well, not the impression.
I need to work on my writing,
that-
Your Honor. So
It wasn't the impression, that was what you argued.
No, Your Honor. No, Your Honor. The concerns about the Establishment Clause that we discuss are to understand the context of legislatures in 1974 when this law was written, and to give some context to the words of the statute. But we can put that aside. I think that the point there is just that Nyquist, the year before this law was rewritten, struck down services like cleaning services, things like ventilation, the sorts of operational things that schools do that under petitioner's reading would also be swept into an overbroad reading of Section 912. We can put that aside and we can focus on the text of the statute and also about some of the undisputed features of this unusual testing program and this unusual public health measure that put it outside the scope of Section 912. This program is not offered upon request or in response to symptoms. It is administered instead to randomly selected groups of asymptomatic students and staff, even though...
It's administered on the request of authorities, right? in the schools, in the individual schools.
No, no, Your Honor, no. That is.
Well, what? So
Well, that's
does
what it
mean in the
says.
statute?
Section
Well, I'm sorry.
912, upon request of the authorities of a school other than public, private, resident children.
Yes.
Excuse me, provide.
I'm talking about DOE's program. I'm not talking about the request of non-public schools. I'm talking about the program that we're looking at, that the other schools are saying we should get that program as well, right? So looking at DOE's program, no COVID tests are administered upon the request of any family, any staff member, anybody. Instead, the test is administered to asymptomatic students and staff randomly.
Counsel, we understand that.
Yes.
We understand DOE's policy with respect to this COVID testing. We understand the surveillance aspect of it, how they're trying to make sure to contain, spreading of the disease, the virus. We understand if you hit a certain mark, you shut down the in-person schooling. I think the bench gets that.
Okay.
The other aspect, the flip side of it is that what's good for the goose is good for the gander, so that the non-public schools, charter schools, parochial schools, under 912 says, you know what, we want that too. So that's the question that I have, is that why then on the 912 that you can't or you won't provide it for them?
Your Honor, because this public health measure is indistinguishable from all the other public health measures that DOE has in place, such as masking, such as the health screening outside of the DOE school, right? So the temperature checks and the questionnaire. I don't know if any of you have children in DOA schools, but every day you have to answer a questionnaire that's very much like the health screening that this courthouse does.
Yeah.
And nobody is under the impression that that is a service made available to people who come to the courthouse. It is something that you must partake in and that you must undergo. It is not a service is something that is provided for the benefit of the person who seeks it out. And so I think what you're getting at, Justice Owing, is that sometimes, depending on the context, COVID testing is something that we seek out, right? I may go to a city testing site because I want a COVID test, right? Yes, Your Honor.
At the risk of having another coughing fit, I just can't buy your argument. I'm looking at the plain language of the statute.
Yes.
And I echo what my colleague just said, that Education Law Section 912 says what's good for the goose is good for the gander. We're not talking about the staff. We're not talking about the teachers. We're talking about the children. How are you justifying denying any segment of a COVID-19 diagnostic test to kids just because they're going to a charter school? This has nothing to do with the Establishment Clause, as you noted before. I mean, you made that argument in the Staten Island case where the Catholic Archdiocese was involved, and you lost there. How can you justify asking us to ignore the plain language of the statute and say we are going to give health and medical services, health testing covered by the statute to one set of kids because they're in public schools, and notwithstanding what the statute says, we're going to forget about the children in charter schools?
Your Honor, I think that the key language is that the statute, it doesn't say we give health testing to students. It talks about services made available to or for students. And just to quickly, before I address the main part of your question, when you said we're not talking about staff testing, that is simply not the case. The petitioners are seeking staff testing, and the court below ordered staff testing.
It's outside the parameters of the statute. I'm talking about what is expressly included within the statute, not to mention the fact that in many schools, you have co-location, where you have kids who are in a charter school alongside kids who are in a public school. And you're saying, test one set of kids, don't test the other. What part of COVID-19 spread do you not understand? What am I missing here?
Your Honor, I think it's important that you recognize that staff testing is not within the scope of the statute, because the petitioners do not, and that is
We're not
because.
talking
That's
about,
besides the
we're not
point. Let's
talking
talk-
about staff, please.
Let's talk
Okay, no,
about the
but-
children.
no, but I'm sorry,
That's a collateral argument. Let's talk about the children.
I'm talking about the children
Okay,
in the
they're
context.
not staff.
May I say one sentence about staff, Your Honor?
No, please, no staff. We're
because the
only talking, please, counsel, really,
okay.
because I, at
The
this
per-
point in time,
okay,
am
the
totally confused about what your argument is. I do not understand it.
Okay.
So I'd like to, try to focus. No staff, okay?
Children.
Only children.
I have-
Please, under the statute, how, under the statute, the plain language of the statute, would it not include children who attend charter schools?
I am going to focus on the phrase made available because I think that that is the most obvious way that the statute doesn't apply here. But if I tell you I am bringing this highlighter to make it available to Your Honors, but what I mean is not that I'm going to ask you if you want it, not let you decline it, but instead I'm going to randomly toss it to one of you at some point, maybe today or maybe tomorrow. And you cannot say you do not want it.
Counsel,
You
you're not
cannot-
making any sense. Especially in light of the fact that there are children from charter schools and public schools sharing the same facility. So don't be talking about tossing highlighters to anybody. Talk about the statute and the plain language of the statute, because so far you haven't done that.
Your Honor, the plain language says services made available. Services are things that people seek out. There are families suing DOE to not.
All right, now, so let's get down to it. So testing and screening, aren't they services?
Your Honor, not when they are randomly administered without any option for students and staff, students who are treated the same, right? Students and staff are the same under the purpose of this program. There are families.
So in other words, something like a vision test, which clearly is involved here, or a hearing test, which children get, even though they may not need glasses and they may have wonderful hearing, that COVID testing to find out if they have COVID and if, and I'm assuming that in these random tests, if they test positive, that these children have to receive certain kind of health attention for that, as well as the policy considerations that are made by the DOE about the functioning of that school, that's somehow different.
Well, it's undisputed that there's no recommended treatment for asymptomatic cases. And that's why this is different from vision screening or hearing screening or scoliosis, because it's not directed.
You're not getting, you screen for vision, kids got great vision, nothing done, right? You screen for COVID, right? You're telling me there's no protocols? Of course there are protocols in terms of what needs to be done for children.
The protocols
Of course there
are,
They may be
the protocols are for the health of the community as a whole, right? You quarantine so you don't infect other people.
And none for the children. Doesn't impact the
It impacts the
child.
children and it impacts
Of
you and
course,
me and the
right?
staff
Child
and
may have
everybody,
to
right? It
not,
impacts
learn
everyone.
from home.
And so it's
right?
fundamentally different.
So
from
I
the
get what you're
other-
saying.
if
What
we-
you're saying is because you didn't mandate it for the schools, but you made it available for the schools, it's not a quote-unquote services, so that charter schools can't ask for it, right? I mean, that's what you're saying. It's not, it wasn't mandated, this was a sort of, the way we're looking at is this testing that we're doing was trying to make sure that there were no clusters going on in the schools so that we have to shut it down. That's where you're pivoting your argument, saying, look, it wasn't a mandated situation for all the public schools. It was a made available services, and therefore, from that point, you're making the argument that because it was only made available and not a mandated service, the charter schools weren't entitled to ask for it.
No, Your Honor, it's not made available to any students or staff. It's required in a random way. But to turn to your colleague's question, the reason that it is different.
You would have done better with his argument, counsel. You would have done better with Judge White's.
It sounded okay.
That made more sense
Well,
to
no,
me. I still don't understand what you're saying.
Under the
and I know
law,
the red light has gone off.
it has to
Yeah,
be.
I'll
it
let
has
you
to be-
answer this question. Go ahead, finish.
This is important because the law requires that it be made available to students. And to turn to your colleague's question, if we look at matter of Richard K., which I think everyone agrees is a leading case on this point, the point is that the service has to be addressing a particular student health need, right? That case was about a diabetic student who needed nursing services. There's no particular need here. We know that because the state has said individual schools may open and operate in person with no
particular- There's
testing.
no particular need
What do
here?
you mean there's no particular need here?
Are we in a pandemic or are we not in a pandemic? Really?
You
You're
don't
on-
have to
you're on-
answer that.
No, yeah, we
We'll
are.
take notice
It's
of
okay.
it. Let's hear from your adversary.
Thank you, Your Honor.
Unless you,
No,
okay.
I tried, I tried.
I like your argument.
May it please the court, I'm Kent Yalowitz from Arnold and Porter on behalf of petitioners, respondents, Charmaine King, and others. I was going to cover some points, but I think that the court understands my argument. I just want to highlight one statement in the record that I think is very important, which is on page 47 of the record. It's a statement by Respondent Appellant Carranza. Chancellor Carranza wrote a letter to all parents in DOE schools, and he wrote that they were doing COVID-19 testing because it was, and I'm quoting, critical to keeping our students, families, and staff members healthy, close quote. So I agree with the court. I don't understand how a
Yes,
program
particularly
that's-
when charter schools share the same physical space as the public schools. So
Correct.
unless you got shields going up, separating them physically, I don't see how that's going to be, you want to test those kids too.
Correct. And
Testing half of them doesn't mean that the other half is not ill.
correct. That was very important to Supreme Court, and that was also important to the judge in Richmond County, of course. I would be happy to. There's one point I wanted to make, if the court would indulge me, about the collateral estoppel issue, which I thought that the city had some thoughtful points in their reply brief, and I think the most important thing that they said, a couple of things that they said I don't agree with. Issues of law can be collateral estoppel. Municipalities can be collaterally stopped. There's no question about that. But ultimately, collateral estoppel is a question of fairness. And the city's argument, and this is where I think they are very soft, the city's argument is that they settled the Staten Island case involving the parochial school kids from Staten Island, and so they shouldn't be bound by the outcome in that case. And I just don't understand that argument. I understand why it's fair to give this testing to Staten Island kids in parochial school, but it's not fair to it's not necessary to give the same testing to the kids of the same age who are going to charter schools in the Bronx or in Inwood or in Jackson Heights or in Bushwick, where our kids go to school. So I think the court can and should reach the merits, but on this issue of fairness, I think there's a point there. So unless the court has questions, I'm going to yield my time.
Thank you.
Thank you.
All right, Mr. Yalowitz, you want to take another stab? Go ahead. Whoa, did I mix you up? Yeah. Oh, I'm sorry. Mr. Matza Brown, I'm sorry.
Thank you, Your Honors. I won't belabor this much longer, but I want to briefly address 2 points. First is the point about the Catholic schools, which I'm a bit surprised to hear because I know Mr. Yalowitz's firm represents them as well, and so I believe he knows the terms of those settlements. Those schools are not doing testing in their schools. They have followed the State Department health guidance and determined they can operate safely without such testing. So the city is reimbursing to the extent that the state requires testing under the yellow zone system, which is now defunct. So there is no provision of any testing in the Catholic schools right now. And that would only change if the state reversed course and reinstituted a sort of yellow zone system. And I just, before I leave today, I just want to emphasize that this testing program is the same analytically as the other measures that DOE is taking to make sure that the school in person, thousands of schools, are not endangering the community at large. So masking, cleaning, and the health screening outside the DOE school, the temperature checks, are all the same analytically as this testing, which under petitioner's theory, testing of staff and students are both covered by Section 912.
I got a question. I just got a real, this maybe is really silly, but what's the harm in actually extending the testing to non-public schools?
Your Honor, the question is not whether the city is trying to do it, which the city is working on doing, and we are trying to work with the schools here. The question is whether Section 912 obligates such programs.
Let's put the statute aside for a second, okay? Let's just put the, sometimes we get so caught up with the statutes and bureaucracy. What's the prejudice to the city to actually do the testing for the non-public school?
Your Honor, as we explained,
Aside from the money issue, clearly, it's a money issue, right?
It is a question of limited resources, Your Honor, and to the extent that the city is going to mandate, right, which involves consent.
Yeah, you're
and
talking
all sorts
about unfunded mandates.
Right, first of all, administratively, we can't just walk into a charter school and make students
So, Counselor,
agree
you're
to
talking
testing.
about walking
But-
into the school. I'm sorry. So you have the charter school and you have the public school in the same building. You have to wear a mask to go into the building. Is that
Yes.
correct? So is it your position, therefore, that if you're in the charter school, you don't have to wear a mask when you're walking into that building because you're going to a separate school, and therefore, if the charter school says no mask, then when you walk into that one public school building, you wouldn't have to wear a mask?
The city Department of Health and the state have some
So
control
is that yes or
over
no?
that.
So again, under this, right, because they're separate, charter school children would not have to wear a mask when they're walking into the building.
The charter schools are bound by their in-person plans that
Charter
were
school
approved by
kids,
the state.
therefore, would not have to wear a mask,
It
right?
depends on the charter schools' plans, and none of the charter schools here had any asymptomatic testing in their plans, right? They all.
you.
Thank you.
Okay, thank you. LabMD versus Buchanan? Right, you may proceed, sir.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the Court. I'm Joel McMull for Appellants, LabMD, and Michael Doherty. I'd like to reserve 2 minutes for rebuttal, if I may.
You have 2 minutes for rebuttal.
Thank you, Your Honor. If ever there was a case that compelled a legitimate second look, I would submit to you, Your Honors, it is this case. This appeal is about appellants being able to hold accountable a former U.S. attorney and her then law firm, Brian Cave, for their failure to do what they promised. And the attendant...
Let me just stop you, because there's a preliminary issue here. Didn't all of the offending conduct occur in Pennsylvania?
No, Your Honor.
It did not?
No.
Well, where did it occur?
Okay.
Where did it occur?
The offending conduct occurred in Washington before the FTC. The Bivens action also occurred there. We've
Oh,
submitted...
so did anything occur in New York?
No.
Did any of the offending conduct occur in New York?
No, and obviously that's a segue to our 487 argument, and hopefully we can talk about that in just a few moments.
Well, we'll allow you argument on it.
But, Your Honors, I would submit here that the trial court got it wrong fundamentally when they said, end quote, that this all boils down to one act of misconduct that is tantamount to perjury or suborning perjury. It is not, Your Honors, and I would submit that if this court should affirm that decision, it turns on its head what perjury law is in this state. Perjury necessarily requires intent, and it necessarily requires testimony. The allegations in the amended complaint are not directed to Wallace, who was testifying, but rather Buchanan, his lawyer, who was involved in a various duplicitous plot as outlined in the amended complaint. But she was also not testifying. She was the one, of course, that was examining Wallace.
Right, But and she didn't represent your client.
I would submit that there was something approaching privity when she did. There's a critical fact here that I want to make sure, and I appreciate the facts are complicated, but there is a critical fact here that I want to make sure the court understands. Wallace was the appellant's witness on redirect. Buchanan essentially intervenes. By virtue of Wallace's immunized testimony, she inserts herself and says, I am the only one who is, by virtue of his immunization...
All right, now let me stop you for a minute. Okay, so she did the questioning, right? And your client was under the impression that she would bring out certain facts that she did not.
Well, it wasn't under the impression they were promised, Your Honor.
All right, let's say they were promised. Your client had an attorney, correct, at those proceedings?
Correct.
And was that attorney present when this redirect occurred?
Yes.
And did your attorney get up and say, Your Honor, I would like to further question Mr. Wallace on the stand. I would like to make a showing that this is not appropriate for my client, and I want to further examine him or cross-examine him because it's in my client's interest and there's a conflict.
I'm not avoiding Your Honor's question. I can't speak to what happened, but I have no reason to believe that what Your Honor described happened.
Okay. Nobody stopped it from happening. You don't know. You don't know. You just don't know.
I don't know, Your Honor, but I know that fundamentally...
He was there, or she was there.
Well, I think part of the problem, Your Honor, is as the complaint, the amended complaint clearly states, the fact that Wallace did what he did, and essentially Buchanan's scheme, comes to light several years afterwards. That is to say, it only comes to light in 2007. The proceeding involving the FTC was years earlier.
So let me ask you a question. This has to do with a specific software that Buchanan allegedly, or Buchanan had and turned it over to the non-party in this action here, which then sort of used it against your client to get all this public, to get all the patient information and use that as to blackmail your client, correct? So
Correct.
it had to do with a specific governmental software. So let me ask you this. What's the purpose of having that come out at the FTC when your client prevailed at the FTC proceeding?
I'm sorry, I didn't hear the first part of
So what is the purpose of actually having Wallace testify to that specific software that he got from Buchanan, or that the company got from Buchanan?
Because Wallace's testimony at the time in front of the FTC was not just confined to the FTC. We make the argument, of course, that there was the pending Ketam action. The Bivens action was an outgrowth of that.
Right, yeah, I'm just saying that, so why specifically having this software identify is so critical?
Because Buchanan is the actor that allows Tyversa and by extension Wallace to get the software. This is a proprietary software, Your Honor. This is not something that you can buy at Radio Shack or Best Buy.
Okay.
Or download for that matter. I guess I'm dating myself. But my point is that Buchanan was instrumental in providing Tyversa a software that, by all accounts, it never had a right to possess.
So if that's the case, why don't you just commence an act, not this action here, but I'm trying to grasp, as a government agent, and when she was in the U.S. Attorney's Office, she provided this software to this Tyversa, right? Was that improper? Was that
We submit, well, certainly, is the mere provision of the software improper? I think so. But more importantly, Tyversa's use of that, and we would submit that Buchanan knew that purpose, which is to engage in a commercial extortion plot, is unlawful. May I just address the 487 argument, if I may, that was brought up?
You may, because you have a minute left. So
okay,
please
thank
say.
you. Real quick, Your Honor. There is absolutely nothing, and I appreciate that this court, as well as others, have made a determination that 487 can only apply to a court localized within the borders of this state. I understand that. But I have researched extensively the statute. Certainly the text of the statute says nothing. The legislative history and the Second Circuit's opinion, the Southern District of New York, this court's opinion, there is no basis to confine a 487 claim to only conduct that occurs in the state of New York. There simply is not. And more importantly, whereas here you have proceedings that were ultimately overseen by an Article III court, namely the 11th Circuit, there's no reason why, if those same proceedings had occurred, let's say, just downtown and we were before the Second Circuit, why that shouldn't also apply. There's simply no policy basis for it. I'd like to
yeah,
reserve the
yeah.
remainder of my time, if I may.
You,
Thank you.
May
You
it
may
please
just-
the court, my name is Ron Minkoff. I represent the respondents, Brian Cave, Leighton and Paisner, and Mary Beth Buchanan. This appeal represents the appellant's 5th attempt to make a claim against my client. My client is not the FTC lawyers who brought the FTC action, not Taversa, the supposed extortionists, not even Mr. Wallace, who supposedly gave incomplete, false testimony, but Mr. Wallace's lawyer. And the trial court got it right when she dismissed these claims, both the tort claims and the statutory claims, and denied leave to amend. And she also got it right when she said on page 6 of the record that appellant's claim boils down to this, that the witness, Wallace, gave misleading testimony about his use of EP2P, this tool, to download the patient information at issue, and my client supposedly ensured that it remained that way. Now, there's a real issue here about whether my client actually questioned this witness, because if you read page 219 of the record, the redirect never happened. There was a direct.
I'm sorry, say that again?
There was a direct.
Right, she was supposed to come in for the redirect. She never did?
There was no redirect because there was no cross. If you look at pages 218 and
There was no
219 of the
cross.
record,
So there was only direct, and then that
it was only direct by appellants.
So she came in and she was a special appearance and she was supposed to do the redirect.
She had the ability to, but
But it never happened.
not according to the
Yeah,
record.
I'm sorry. Can you just tell me where in the record I'd find that?
Page 218 and 219, you'll see that there's no redirect. They talk about the direct, and Wallace was called by appellants. And then there's no cross by the FTC, and there's no reference to a redirect.
So is it that we know definitively that there was no redirect, or we just don't have a transcript indicating a cross or redirect?
It's not mentioned in the judge's decision where he's going through very painstakingly. So that's one issue. But
All right, one other thing, just so that I'm clear what your position is on the record. Wallace was questioned on direct, and that was by appellant's lawyer.
right. So this appeal, but in any event, even assuming that it happened exactly the way they claim in the pleading, which is the judge asked the question, Mr. Wallace gave an incomplete answer to the question. He was asked, what do you mean by downloading, viewing, and searching? And he responded that he used the standard off-the-shelf peer-to-peer client, such as LimeWire or BearShare, and he went on, and he doesn't mention his use of EP2P. And they claim that is not perjury if he didn't mention EP2P because he didn't make an explicit statement or he didn't do it intentionally. So if they say it's unwitting, then it's not, covered by what we call the subordination doctrine. And the subordination doctrine is designed to prevent them from getting a do-over, to prevent them from coming back after the case is over and saying, this witness testified incompletely, this witness testified incorrectly, he lied, whatever it was. But the claim here is that there was intentional misconduct by Ms. Buchanan. Over and over again, they accuse her and my client and the firm of misleading the court, of intentionally doing it, of having a motive to do it. And and that falls directly under what we call the subordination doctrine, this 200-plus-year-old doctrine that New York courts have had.
It says that she didn't elicit any testimony from Wallace that Taversa used the EP2P, or fully bring out the origin of the hack. And that she avoided questions, Buchanan avoided questions that would elicit this testimony.
Right. Well,
If she did not take part in the proceeding, then I don't understand how she would have avoided questions that would elicit the testimony.
Well, she didn't question it, but even assuming that she did, and as the way they have put it here, the fact is that she did not, that even if she did exactly what they say they did, as we must assume on a motion to dismiss, even if she did that, they're saying that she did it intentionally, that she withheld this information intentionally from the court. And if that's what they're claiming, then it falls under the same doctrine of what we call the subordination doctrine that says that you can't, in a second case, accuse a witness in the first case of lying or the lawyer of suborning the perjury
So I'm
or
gonna ask
any
you-
fraud on the court.
Just something a little off point, but it's related to what I asked your adversary. So couldn't the appellant's attorney have elicited that information from Mr. Wallace?
Look,
If
it's
it
our,
wa-
it's our position that the appellant's attorney didn't do his job here. There's an issue about spread and whether or not there was, he was supposed to ask about the spread of this material, the false allegations.
In fact, the FTC judge, the judge at the FTC proceeding, asked those kind of pointed questions to Mr. Wallace, right? I mean,
Absolutely,
where did
and
you
it's
get?
in the
Where did you
record.
where did you get the software? Where'd you get the? How'd you get this device? Or, I mean, those were pointed questions asked by the judge.
That's exactly right. That's exactly right. And the judge and Mr. Wallace answered incompletely. If the
Well, the reason why the
lawyers,
judge had to ask is because the attorney representing the appellants never asked the question, I guess.
well, but the issue of spread, which is one of the issues here, is in the record, in the judge's decision, again on pages 218 and 219, they talk specifically about spread during Wallace's direct. So I just want to make one point about
see?
Section 487.
Okay. All right, we're gonna hold that. First of all, you're out of time.
Okay.
And we're gonna take a very short recess. We're gonna take a 10-minute recess. Go ahead. Go.
10.
Yeah. Go ahead. You go first. No, don't be sorry.
Don't go anywhere.
That's what I think.
appreciating the disruption. At this point, we'll hear rebuttal. You have 2 minutes.
Thank you, Your Honors. Very briefly, having now had the benefit of that brief recess, turning then to pages 218 and 219 of the record, what I understand my adversary to be referring to specifically is the second paragraph on 219, where there is a chronicling of the direct and the cross, and it notes the absence of cross. I do not read it in the way that my adversary does. I believe one of the justices asked, is there a transcript in the record? There isn't. And I would submit that to the extent that's going to be the basis for a finding that there was, a procedural finding, I think that's a little inadequate. The other issue I'd like to raise, Your Honors, if I direct your attention to paragraph 96, page 174 of the record, I'm at a loss to understand, in light of Ms. Buchanan's statement to the FTC, and there you have in full the basis of her letter application when she requests to conduct the redirect of Wallace, how if in fact that did not occur, how that is to a respondent's benefit in light of the fact that she would have been the one to, at a minimum, recall Mr. Wallace in the context of rebuttal. So the fact that she didn't fulfill the obligations that she sets out in that letter to the court, and when she talks about a truth-finding mission, and that she was essentially going to ensure that the truth was going to come to light, the absence of her doing that, I think, only further bolsters our position. Finally, and lastly, my adversary indicated at the very beginning that the court properly ruled denying leave to amend. With respect, Your Honors, that is not accurate. There is a Fourth Department case which this court in turn has actually cited for authority on that. And at the end of the day, a motion to dismiss pursuant to CPLR section 3211 is not tantamount to a responsive pleading as defined within CPLR section 3011.
Counsel, you had already amended.
I had amended, but I had amended, or we had amended as an outgrowth of a resulting motion.
Right, but
there was
then
never any responsive pleading.
You were stating that you could amend without leave.
Correct.
So if you had already amended, how under the statute 3025 would you be able to amend a second time without leave? The statute says once without leave.
Because there was no responsive pleading, Your Honors. I mean, the activity that the respondents took here, they could have answered, locked us in, and essentially moved on summary judgment. And while I acknowledge that it creates a bit of a procedural morass.
Does 3025 talk about responsive pleadings? I thought it just talked about whether you could amend without leave. I'll take a look at it. It's okay.
Okay, thank you.
I have nothing further.
Thank you both. Right, the next case is People v. Donna McCrae. I'd like you to set up. I'm going to let you go. No, I'm going to let you go. Done. Okay, and I'm just going to make an announcement for the rest of the arguments that are on today that, where are you? Justice Gonzalez is not feeling well, and she at this time is not going to be here for the remaining oral arguments, but she will be participating in the deliberation of these last two matters. And those of us that are remaining will hear oral argument, and Justice Gonzalez will have access to our streaming and taped arguments. Thank you. Okay. Okay, you may proceed, Counselor.
May it please the Court, Tabitha Cohen from the Office of the Appellate Defender on behalf of Donnie McCrae. The 2016 warrantless search of Mr. McCrae's car was not a valid inventory search. Both the purpose and procedure of the search were improper and impermissible under New York law. First of all, the officer who conducted the warrantless search testified that he conducted the search in order to find contraband. In other words, this was a warrantless investigatory fishing expedition that he later justified by calling it an inventory search. The purpose of an inventory search is to protect property owners against lost, stolen, or damaged items, and the police against liability. While incriminating evidence may be the consequence of an inventory search, it should not be its purpose. Both the U.S. Supreme Court and the New York Court of Appeals have held on multiple occasions that inventory searches should not be a ruse for a general rummaging in order to discover incriminating evidence, but that is exactly what happened here. That improper motivation alone renders the purported inventory search invalid.
Excuse me, counsel, we're talking about Officer Gans?
Yes, Your Honor.
I missed a part in his testimony where he said that it was in order to recover contraband.
Yes, Your Honor.
Where did he testify to that?
On page 19, during his direct, when the prosecutor asked him why he conducted the search, his initial answer was to find more contraband. And then additionally, on cross-examination on page 55 of the suppression hearing, he repeated it again, that he conducted the search in order to find drugs.
The inventory search?
Yes, Your Honor. When the prosecutor asked why he searched the car, his initial answer was to find contraband.
I thought that that was at the scene. I didn't realize that that was the inventory search.
Yes, it was the inventory search, Your Honor.
Okay.
So the automobile exception would have allowed them to search the car in any event, correct? At the scene. Let's start with at the scene.
At the scene, we would argue that he was not permitted to search the car under the automobile exception because Mr. McRae and his son were both handcuffed behind the car. There was no exigency. The car was no longer mobile, and the police did have opportunity to obtain a warrant. However, more importantly...
We're talking about because they brought the car back to the precinct, right?
After they brought the car back to the precinct, respondent again argues that they had justification to search the car under the automobile exception.
Right, and so really all I'm getting at is how do you distinguish the case of People versus Hurtado, where that's what happened. They had a right at the scene to search the car, they didn't search it, they brought it back to the precinct, and the court in that case said that's okay, that it continued, the right to search the car continued to search it without a warrant, notwithstanding that it was brought to the precinct. How do you distinguish these two cases?
Yes, Your Honor. In the Hurtado case and in all of the cases that respondent cites, there is no indication that there was a several-hour delay between when the police seized the car and when they searched the car under the automobile exception. We argue that that several-hour delay posed ample opportunity for the police to obtain a warrant. The rationale for the automobile exception no longer applied, and the police had several hours to obtain a warrant, which they did not here.
And the rationale for the exception is?
Exigency and the inherent mobility of cars and the potential that someone would be able to, let's say, conceal the contraband or dispose of the contraband or place officer safety at risk. However, that no longer applied here when for several hours the car was secured in the precinct garage.
And the car was in the custody of the police.
Exactly.
And see, that's why that was my initial confusion, because he testified that the vehicle was searched at the scene, and then when it was taken to the precinct, he continued searching the vehicle to see if there was any additional contraband, which fits within Hurtado, does it not?
It does not fit within Hurtado because there was a several-hour delay. It wasn't as if it was a continued search from when he conducted the initial search during the car stop. He waited several hours, lodged the defendants, and then several hours later conducted an additional search, which he initially tried to justify under the inventory search exception, and then respondent fell back to the automobile exception after he said he conducted the search in order to find contraband.
Well, would it have been permitted at that time when it was brought back to the precinct for him to do an inventory search without getting a warrant?
So either the car was searched under the inventory search exception, which the rationale for the inventory search exception is to find property. The police in that case wouldn't have probable cause to search the car in order to find contraband. They would simply be doing it in order to protect the property and protect the police
True
from
enough,
liability.
but if they found contraband in the course of an inventory search, that would not be evidence that's suppressed.
If the purpose of the search was in order to protect the police from liability and protect the property, then correct. If they happen to come across incriminating evidence during the course of that inventory search, that would not be able to be suppressed. However, if the purpose of the search is in order to find contraband, they are not permitted to call that an inventory search. They should have obtained a warrant, and they had ample opportunity to obtain a warrant. Additionally, not only was the purpose improper here, but the procedure for the inventory search was also improper here. Officer Gans did not produce the single hallmark of a valid inventory search, which is an inventory list. Instead, he only vouched the potentially incriminating evidence that he found in the car, which further bolsters our argument that he did this in order to find contraband and that this was an investigatory
But
search.
the other officer took photos of the vehicle, right, of the trunk, clothing, and other things. I think there was like sneakers or something, or shoes. So, I mean, although maybe there wasn't a written inventory, there were photos which showed exactly what was in the vehicle, in the trunk.
The photos taken were only of, let's say, a box with several items in them, or potentially incriminating evidence such as a shoe with pills in it. However, you cannot see past the first layer of items in that box. There was
But
no
there was
inventory of
there was
the
a
items in the
voucher.
box.
Didn't Gans also voucher everything that was removed from the vehicle? So we have the voucher as well?
No, he only vouched the potentially incriminating evidence that he chose to remove from the vehicle. Everything else that he left in the vehicle, there is no inventory for, and it is not listed. In the 2018 case, Officer DeLillo did follow the proper procedure. However, he also stated that his purpose for conducting the search was in order to find contraband, and the New York Court of Appeals has held on multiple occasions that improper purpose alone can invalidate an inventory search even if the proper procedure is followed. In the 2016 case, however, Officer Gans believed he had unfettered discretion. He testified at the suppression hearing that there is no direction on how to, I see that my red light is on.
You can finish your statement.
He believed that there was no procedure and that he had unfettered discretion and acted accordingly. In light of all of these arguments and the arguments laid out in our briefs, the fruits of the illegal searches should be suppressed and Mr. McRae's conviction should be reversed.
Thank you.
Thank you.
You may proceed.
Good afternoon, Your Honors, and may it please the Court. Jillian Lewis for the people. Your Honors, the 2016 car stop is valid under the long-recognized automobile exception to the warrant requirement. The Fourth Amendment allows a warrantless search of a vehicle when there's probable cause to believe that contraband can be within the vehicle. Here, Officer Gans witnessed the defendant and Mr. Thomas smoking marijuana. This provided the cause necessary to stop the vehicle, and upon stopping the vehicle, witnessed an additional piece of contraband, an orange pill bottle in the front console.
Well, I'm going to ask you what I asked your adversary, which is assuming that we get to that point. We had probable cause, they searched the interior of the car, they found more stuff, it gave them further probable cause under the automobile exception to go into the trunk. Does it matter that they brought the car back to the precinct and then waited 3 hours without obtaining a warrant before going into the trunk and searching it? Did the automobile exception continue to apply? And if so, why?
Yes, Your Honor. The automobile exception continued to apply. The time that is cited by the defendant is not noted in any of the cases. The stop occurred.
Well, what is the purpose of the automobile exception?
Your Honor, the purpose of the automobile exception is to secure a vehicle and provide opportunity to search for additional contraband when a crime has occurred. So
Is that really what it is? It's not what your adversary explained, where she said it's due to the fact that a car is inherently mobile and you don't want the evidence to necessarily disappear and other exigencies that are apparent in a stop, in an automobile stop?
Yes, Your Honor, that's part of it. However,
Sure, but those particular rationales, they no longer apply once the vehicle is secured within the precinct. Isn't that so?
Your Honor, that is correct. However, this court in People versus McKinley, Hurtado have shown that an automobile exception is extended to the precinct rather than
They do say that. It's a little curious. They don't give a rationale, but let's talk about that, you know, where you started, which had to do with the temporal issue. So is there a temporal limit to how long you can have a car at the precinct in the custody of the police before the automobile exception stops applying and the police have to go and get a warrant to search the car for contraband?
Your Honor, while I'm hesitant to apply a specific rule, this is not a case where there's a day or two lapse in the search of the vehicle. When the vehicle was initially stopped, it was on the 145th Street bridge. It was a busy bridge, and the initial search of the car was very cursory before being brought back to the precinct. Now, page 70 of the record indicates that the car was brought back at around 3:45. The defendant was then booked, and then the officer Gans went back to the car and finished the inventory search. He talks on page 70 of the record between 6 and 8 that occurred. It occurred over a half hour, but it was conducted by 8 p.m. So that isn't a long lapse like we're talking about. That's a very quick process in which a warrant isn't.
Is it long enough to get a warrant?
Your Honor, warrants can take different amounts of time, so depending on the situation. But here, the law was clear that it wasn't necessary to obtain a warrant.
Okay. Can you explain to me on the 2016 incidents why no Mirandas were needed when the defendant was in cuffs?
I'm sorry, why they were needed?
Yeah, why your claim is they weren't needed, and he was in handcuffs.
Yes, Your Honor.
Was he free to go?
Your Honor, while he wasn't able to leave the handcuffs, they were merely investigatory questions, asking questions to get a better sense of the scene. The question, who is Quinton Williams, was a question to determine who the owner of that oxycodone was. They had not yet established who the occupants of the vehicle were. And, People versus Mattis has shown that you can ask someone questions like, have you been drinking? Further investigatory questions. And that is what happened here, which is why Miranda...
My question is really, do the handcuffs change that? Because somebody's not free to go if they have handcuffs on, right? Isn't that true?
While they're not free to leave the scene, it was clear that there wasn't an interrogation occurring, that this was preliminary at the scene. They were being taken out of the car, put in handcuffs in order to get a better sense of what was going on. And factually...
Why did they need to be put in handcuffs to get a better sense of what was going on? What does that mean?
Well, Your Honor, the officers were at a busy bridge when they initially saw the bag of marijuana and the pills in the car. So removing the...
So were they arresting him?
Your Honor, at the time of the un-Mirandized statements, they were not under arrest.
Okay, thank you.
Thank you.
Okay, you can proceed.
Your Honors,
Why didn't that reset? Let me try again. Huh. No. Okay. Oh, I know why, because you only got 2 minutes. Go ahead. I only gave you 2 minutes. Go ahead.
Your Honor, warrantless searches are per se unreasonable unless the prosecution affirmatively establishes that an exception to the warrant requirement applies. Here, the prosecution has not met that burden. They did not demonstrate affirmatively that this was a valid inventory search and that Officer Gantz was either aware of the procedures or that he followed any of the procedures pertaining to inventory searches. Additionally, they have not established that his purpose was in line with the purposes set forth in New York case law for why inventory searches are valid. He conducted this warrantless search in order to find contraband, despite having ample opportunity to obtain a warrant. Additionally, as Your Honor noted, there was no exigency here. The rationale for the automobile exception is that cars are inherently mobile. However, a several-hour delay provided no opportunity for either the car to get away from the precinct or for any of the contraband to be disposed of before the police could obtain a warrant. They cannot have it both ways, and both argue that this was a neutral inventory search and argue that the police had probable cause to conduct a search under the automobile exception. Additionally, briefly on Miranda, as Your Honor noted, Mr. McRae was in handcuffs at the time that the police were asking him questions pertaining to both the marijuana cigarette and the orange pill bottle that they found in the car. This was clearly a custodial interrogation under both federal and New York case law.
We do have some case law, though, that says that notwithstanding that somebody's in handcuffs, that it's not necessarily a custodial interrogation. Is that true?
Mr. McRae, any reasonable person would not have felt free to leave when he is in handcuffs next to a police officer. For all of these reasons, Mr. McRae's conviction should be reversed. Thank you, Your Honors.
Thank you. Thank you both. All right, Vicar versus Port Authority.
May it please the court? My name is Scott Singer, and I represent the plaintiff appellant in this appeal. With the limited time available to me, I would like to address what I regard as two fundamental flaws in the legal analysis contained in the defendant's reply papers. As to the applicability of Labor Law Section 240, defendant contends that the statute is inapplicable because plaintiff's co-workers deliberately pushed the rebar cages down the makeshift ramp. The problem with this argument is that it ignores the holding of the most relevant case, the Court of Appeals decision in Runner against New York Stock Exchange. In Runner, the court is aware that the plaintiff's co-workers actually pushed this large reel of cable down a staircase that precipitated a chain of events that caused the plaintiff's accident. I can't think of no reason why the same analysis doesn't apply here. In both cases, the accident was clearly gravity-related. In both cases, the absence of proper hoisting device and ancillary equipment was a cause of the accident. The second flaw pertains to an evidentiary issue. The defendant contends that the plaintiff's accident reports were inadmissible as business records. But in doing so, it ignores the fact that these weren't merely business records. These were admissions. They were prepared by the defendant's safety manager. They were adverse to the position that the defendants now espouse. And admissions are treated very broadly under the law. Essentially anything contained in those reports is admissible. I did hand up, because this contention was first raised in their reply papers, I did hand up one additional case, Bruska against El Al Israel Airlines, where this issue is discussed. The courts are not going to scrutinize particular aspects of a report that is an admission and as such is admissible in their totality against the defendants. So these reports were extremely important, and they essentially were indeed admissions of the central issue in the case. And I point particularly to one of the reports. It's called the Flash Report. It's found on page 97 of the record. In that report, primary and contributory root causes: the rebar cage rolled faster and further than anticipated. There was no backstop or mechanism in place to stop and control the rebar cage once it was rolled off the steel horses. In other words, as far as I'm concerned, the case is over at that point. Defendants admit that they didn't provide devices that they should have provided. They didn't provide alternatively hoisting equipment that they should have provided. Both of these
right. Your position is that they should have provided hoisting equipment, and there seems to be a lot of evidence in the record that that is appropriate. They did. You also had as an alternative claim that at the very least there should have been a Jersey barrier at the bottom here. This 1,000-pound rebar cage that was rolling down a ramp. Correct?
That's correct.
Right. And they did have an expert that said, oh, no, hoisting's not the only way. You can roll this. But I didn't recall, and maybe I overlooked it, I didn't recall anything that their expert said about whether there should be a Jersey barrier.
I don't think their expert addressed that, but I think more broadly, their expert really missed the point. He relies on this idea that, oh, it's the customary practice to do this or do that. And we know since Zimmer, the customary practice in the construction trade is not dispositive of these cases. It doesn't matter what the customary practice is. It matters what's going to give the workers proper protection, and that wasn't done, both because of and I cited case law where hoisting equipment should have been provided, and I cited this court's decision in the Grant case, where it wasn't a backstop, but it was something very similar. It was blocks that would have been used to prevent these large loads from tipping over. So these are kinds of devices that fall within the purview of Labor Law Section 240. There was no question that they were not provided. There's no question that the accident would never have occurred if they had been provided. There is no basis for distinguishing this case from Runner. It's almost exactly the same situation. Both were clearly gravity-related accidents. They're in the core of Labor Law Section 240 protection. And there was essentially also, there was no dispute as to the facts. I don't know if I used up my last minute. Did I reserve?
You used it all up.
I used it all up.
Last
Okay.
second.
Okay, well, thank you.
Thank you. You can proceed, Counselor.
Good afternoon. May it please the Court, Allison Snyder with Fabiani Cohen and Hall for the defendants, respondents, appellants. I'm not going to spend much time on Runner just because...
No, spend some time on Runner,
Okay.
because I was just going to ask you about Runner.
Okay.
How do you distinguish Runner? I mean, I have to say, Runner is like the poster child for 241.
Except
tell me, why isn't this a Runner case?
It's the exact opposite of Runner, because if you read what the decision says, the reason why they were moving that 800 pound reel in that way was it says, quote, to prevent it from rolling freely, they tied the rope to the reel. The situation was they were trying to move this wire reel indoors down 4 steps. That's not what we have here. And with regard to the situation of
but they were moving a heavy object. You say 800 pounds. I thought I saw 1,000, but we'll go with 800. And they were rolling it down a ramp. It doesn't. Listen to my question, though. Doesn't that necessarily involve gravity?
Yes.
Of course, right? Because that's the whole reason they're using the ramp. It's easy, right? You just roll it. Doesn't it stand to reason that they should have had a safety device in connection with the mechanical operation of rolling this object down a ramp?
No. Your Honor, the Court of Appeals has been very clear, going back to Narducci, in Uttar,
and in even in Fabrizi, where they brought it all together. And what they've said is, when it comes to the initial applicability of labor law, it only applies when an object is either being hoisted, when it's being secured, or it requires securing for the purpose of the undertaking.
Well, why would, and that's my question to you.
But the
Why
undertaking-
doesn't it, the undertaking is moving this heavy object, and why wouldn't it require some securing, if not just a backstop, so that the thing doesn't roll wildly out of control?
Well, Your Honor, the whole point here was to move the rebar cage from on top of the sawhorses down to the ground, and it did that. It did that exactly as intended. It wasn't as if the sawhorses broke. It wasn't as if the ramp
No,
was
but where's the
affected.
safety device there? That's the question.
Except, Your Honor, that's putting the cart before the horse. The horse was whether it required securing for the undertaking. The undertaking was rolling it from atop the sawhorses down the ramp onto the ground. And our expert has said, of course you don't need to secure something that you're intentionally moving. And if I can just say...
But that doesn't make sense, because most
Your Honor, if I can, I just want to point out there are 3 cases that demonstrate this precisely. We've cited Vega, we've cited Donnelly, and we've cited Corey. In all 3 of those cases, the accident happened within a containment area. And even in that situation, when the plaintiff wandered into the containment area, the court said that Labor Law 240 doesn't apply because it was deliberate. This wasn't accidentally dropping something.
Where was the containment area here? Maybe if you had a backstop as a safety device, you could say there was a containment, but there was no containment.
Your Honor, if you read Corey, what they specifically say is when it comes to like setting up a containment area, that goes to methodology. But that's not what you're looking at initially when you're looking at whether or not labor law applies to a deliberate release. And that's what the court is saying in Roberts. The Court of Appeals in Roberts said it's antithetical to say that...
but in Runner, they were deliberately moving the coil. They wanted to move the coil.
Except that they...
It had to go from one spot to another. What makes this different?
Except that they were trying to inhibit the rate at which it was being released down that ramp. They were trying to control it, and they used, by tying it off, they used inadequate means. And so in order
So your argument is if they use no means, they're in better shape than if they use inadequate means of a safety device?
Yes.
So if you use an inadequate safety device, you're in 241, but if you use no safety device at all, even though you have something that it might require a safety device, no big deal.
Well, how did it require? I guess.
How did it require? It was 800 pounds rolling down a ramp
into an open field.
You know, counsel, I think that was kind of like sarcasm there. I mean, it makes no sense that to not use any safety device would not put it into Labor Law 240.
Except that the undertaking is whether or not it needed to be secured, and didn't need to be secured if you were purposefully rolling it down a ramp.
I'm not sure I agree with that, but I'll consider your argument.
Thank you, Your Honor.
Okay, thank you.
Thank you. Have a good night. Somebody got some stuff downstairs?
Yes, that's mine.
Take care.
It's all mine. I'm not used to the new program.
Have a good night. Somebody got some stuff downstairs?
Yes, that's mine.
Take care.
It's all mine. I'm not used to the new program.